So I was asked to discuss with, again, to students, the importance of intellectual property. And I decided that a bit with the themes of the WIPO Day this year, which was bring idea to asset, from idea to asset, and quite an amount of work that we have been doing on innovation and how to promote innovation through intellectual property. I wanted to discuss again quite generally. This is a 20 minutes presentation, 25 minutes presentation. Some of these linked, and also since this audience is an academic audience, it's a student audience, used to critical thinking, and my fellow co-speaker has a lot of expertise and experience on the patenting side of that. One of the things I hope I can highlight is that this link between more IP means more innovation is not necessarily proven. So yes, it's important to have IP. It's important to have IP for managing, monetizing innovation, but not always innovation needs IP, and sometimes too much IP actually gets in the way of innovation. And this is something that we need to remember. I think now that's clearer than ever, and I hope all of you are safe enough. We know that India is going through a particularly difficult time right now, due to COVID. I'm in Singapore, and we are having also another massive waves. Singapore's size, of course, smaller, but we have been dealing with variants and some revival of the infections that clearly show, and looking at the WTO discussion, the waivers, the IP waiver discussion, the fact that India being the biggest producer of pharmaceuticals, generic pharmaceuticals, we really need to put the big question marks about IP and innovation. I am very much a believer that IP is very useful for innovation. However, I don't subscribe to the narrative that we always have to have IP to have innovation, because sometimes it's actually very good not to have IP, and sometimes history has proven that the best inventions happen a bit by chance and not really because we have a lot of IP behind it. And on the other side, I think for entrepreneurs, it's important to understand the IP ecosystem, both with its protection and limitation and exceptions, in order to use it, in order to understand when they need to seek permission, when they can just do without permission, when they could seek permission and take the risk not to seek, to just do something, and what a potential lawsuit would mean, and how they can negotiate transaction. Often, we can start and we can get into a lawsuit, and then we can just have a transaction that resolves a potential dispute between litigants, in which I want to get, you give me a license, you don't want to give it to me, I still do it, you have no way other than suing me, and then we settle and we get to some sort of agreements. All these are, very relevant point that we need to consider as those who study and those who teach intellectual property. Apologies, I'm fighting with two screens that for some reason today work less good than usual. Intellectual property is what it is. You have a lot of very fancy pictures, but in reality, intellectual property is the creation of many minds. Innovation is never the result of one individual. It's the result of multiple individuals. It's the result of incremental innovation, of finding that spark for something that many others might have tried before, and now we can just figure out a way to make it all work. And so, this is an ecosystem in which really we see teamwork, we see infrastructure, we see education. There are so many factors to innovation. than just, law that tells now you have a patent, now you have trademarks, or now you have copyright, because you can have all the law in the world if you don't have really good products or a good idea, and a good innovation and education system behind, that doesn't really go anywhere. And so this is really where I think we should situate the conversation. We live in the world of ranking. Everything is a rank. We have the innovation rank. Country fight to be as high as they can in the innovation rank. And so number brings up us, the more patent we have, even though half of this patent might be useless, bring us higher in the innovation rank. And so all these questions are important. And then, to be higher in the innovation rank might trigger more foreign investments. If we have a better ecosystem, those numbers can verify it, and so on and so forth. But this is also, these are somewhat slippery slope narratives very often, because we can have a bit too much emphasis on the product side versus the output side versus the input side. Let's remember, innovation is done primarily through technology, development of technology, and technology is done primarily through a lot of education and also risk takers. Risk takers are those throughout history who have had some capitals, some infrastructure, but then they tried, they failed, then they tried again until they succeeded. And perhaps not on what they initially thought, but with a variety of adjustments. So this is really why, when we think about IP, we need to think about IP, on very much on an ecosystem. Of course, IP today applies to everything we see. We live in a world of image, we live in a world of licensing, we live in a world of permission. In which, if I take a puzzles or a box of toys, I will have trademarks compiled with copyright, designs, and a bunch of patents in the toy themselves. And so, the more the merrier. We have transitioned to an economy which is largely a service economy, particularly in developed countries, in which manufacturing has been largely substituted by machines, plus what has not been substituted by machine is often done overseas. And so, this service economy also brings not just more IP, but more people who actually do IP, like filing. And so IP offices also are incentivizing as many file, no simplifying procedure. And so there is a big rush to, why not have all these rights? Why not have more protection? Why not? Well, sometimes it's because it's too much and it actually can become counterproductive. These are just, again, some example of products that have a lot of intellectual property, and intellectual property that today goes also beyond the traditional. For example, the shape of products was once upon a time protected just through design. Now is also protected through shape trademarks, almost invariably. Unfair competition is always added to registered trademark protection. Often, commercial products such as watches, lamps, covers of smartphones are also copyright protected. And so, you start to see this ecosystem of evolution in which not only we have IP, not only we manage it and we push it to a lot of intellectual property, but we also are piling and overlaying multiple types of protection in the management. Again, many of you will be lawyers. You should do what's in the best interest of your clients. Looking at the current law, you should have a lot of protection. But if you are the competitors, you might be the lawyers of the competitors. You will see that the more IP, the more problems sometimes. And we know the judges often don't really like a lot of these rights. And so if we get to the final stages of litigation, particularly at the appeal level, often our IP, particularly one is non-traditional trademarks rights, or sometimes a bit excessive copyright protection, and sometimes patent protection as well. Just the court says they might not go all the way to say that the right is invalid, but they don't find infringement. And so, intellectual property, I like to put pictures in my slides, is a bit like a tree with all these various, these various variables, these various flowers, and these various leaves. IP is, you know, a large ecosystem, and we know the difference between property and intellectual property is the fact that we have a human-made regulatory system. You know, I always make the example to my student, either I have that phone or you have your iPhone, either you have that one or I take it away from you and now I have it. But the patents, the trademark, the copyright in it can be replicated by everybody without taking yours away. The only thing that is taken away is the value, because the value of intellectual property is in the managing, in the prohibiting others from using without consent. And so, you know, this is very much the ecosystem of intellectual property. You know, patents, trademarks, copyright, design, trade secret. Of course, there is geographical indication, traditional cultural expression, traditional knowledge. But this is really the bulk of the intellectual property protection as we look at it today. And so each of these is supposed to have a function. Trademarks identify the origin of the goods. Geographic indication identify the region from which the goods come. Design identify the shapes of the goods. Patent protect the processes or the products or the technology associated with it. We can also protect technology through trade secret. And then copyright is supposed to protect intellectual creations. You know, but every product, as I mentioned before, it's really protected through a variety of intellectual property. So the solo practitioner of patent law only today, it's a bit out of fashion because we need to understand a bit the other rights. You know, some of you might later today, tomorrow, in the future, being, you know, those very high-end litigators in one specific field, but very few people get there. The vast majority of IP practitioners is going to practice a portfolios of intellectual property rights and manage those portfolios. And you have better knowing a bit of the other rights, not just trademarks or patent or copyright. Again, because different rights can serve to protect different parts of the same products and actually can be leveraged to reach out more, you know, overall for a certain products. You know, again, you see kind of Coke as trademarks, as copyright, as trade secret, of course, as patents, now expired. And so, you know, I'm going to skip, you know, the basic. I'm going to send the slides to the professors. You know, where do I want to go? I want to go to see that we have strong protection, but we also have limitation to this protection. And so we know IP should be an incentive for innovation, but also IP should not go in the way of innovation. And because of that, we have limitations and exceptions. And as we need to learn to manage the protection side of IP, we also need to learn to manage the exception and limitation side of IP. And I think, you know, India has led the world in many ways in these, issuing compulsory licensing in several cases for needed medications, for example. India has also adopted, you know, certain, just the fact that in India, you can't really evergreen a patent as easily as in another country. So all these are legal instruments through which either by using somebody else's right under a special flexibility, or by just increasing through the flexibility that the law gives the burden and you know, and the level for the protection, and so not something that is almost obvious or already known, ready to expire, will be protected. All these are very relevant things to know. So the best practitioners in IP are those who are able to litigate and understand all the management, from the ultra protection to the ultra exception in many ways, and understand all the nuances between that. Now, what's interesting is that certainly the world's most innovative economy are very strongly tied to IP. But let's not make the mistake to think that IP necessarily was the drivers initially. A lot of these economies are heavily based on initially copying and then protecting when they actually started to develop strong industry in which others could copy them. And so they wanted more IP. And take the case of Finland, Germany, Sweden, the United States, Switzerland. There is so much more to it. There is strong education, banking system, financing, rule of law, courts that work, that they're not corrupt. With all the problems of any imperfect society, some of these are, probably some of the best you can get. And so I think this is really important for us to understand. Some of these are very hands-on government control. So government as a pusher for innovation. Others have a very hands-off government approach. Some comes really from the bottom up. Other is very much a top-down approach. Switzerland, interestingly, is the world's most innovative country. This is, you can have a bit of this variation, but certainly Switzerland has a very strong patent tradition, but that's not just what it is. There is a lot of innovation that goes on in Switzerland, that it's linked to the education system, to the high wealth of the country, to the financial system, and so on. So what's interesting is also, again, looking at geographically whether, and this is very much a reflection of the Industrial Revolution in many ways, industrialization. But then if you look at India, I think it's really interesting to see, the cluster of innovation in India are very, very high. This is often information technology related cluster, or clusters that relate to the biopharmaceuticals and similar cluster. But so it's very interesting to see how much blue there is in India as well. I was not long ago when we still could travel in Bangalore, in your beautiful techno city, and that's really was also very interesting to see all the companies there and the innovation ecosystem that is going on in India as well. And so, just to quickly conclude, I think it's really important always to think about these various variables. We need to understand IP, we need to understand how to get it, we need to understand what it is, when, and I have more slides that I'm not going to read, at which stage of the applications, the enforcement, the transaction, what type of contract to do. But it's very important to understand that the management of IP and the innovation ecosystem, it's sometimes understanding that we have an exceptional limitation, and so we don't need to have a license. This is really crucial. But to understand that, we need to know intellectual property and the licensing agreement terms. We need to understand specifically all these rules, and also the enforcement ecosystem, of course. And so with that, I conclude, and I will be happy. I don't know if you take question up front or you take question at the end. Thank you again for your very nice organized event. Very many thanks.
So the topic I was going to speak to you on today is it's a bit of a mouthful. It stems from my research into the places where intellectual property doesn't really work or doesn't really show up. And I like thinking about this topic. I think it ties really, really well with Professor Kaboli's previous talk, because I completely agree with her that intellectual property doesn't actually create innovation. It generally does other things. And my research has really shown me that what intellectual property is doing is generally, in fact, allowing strangers in markets to communicate with one another about goods in general. And a lot of my research has kind of unpacked that, because the research that I do looks at the way intellectual property is negotiated or is used by groups of people who are innovating or creating in close quarters. So I've looked at a range of different groups. The ones that I will talk to you about today are doctors or physicians. I will talk to you about soldiers and about people working in the music industry that isn't the sort of big pop factory, Michael Jackson, Taylor Swift music industry, but the music industries that we're probably more familiar with that are closer to our communities. So in that sense, it will be quite a broad survey, but it's meant to introduce you to this idea of the places where intellectual property isn't very prominent, even though you might think it would be. So the intellectual property laws that we understand are ideologies, and I really commit to this idea that intellectual property is an ideology that's very specific to a time and place. And I think to understand intellectual property, you have to understand that many of the rules developed in a sort of nascent consumerist capitalist markets in Western Europe, England, and in a period of time when societies were grappling with how they were going to, how people were going to be able to exchange goods in a market. So, for example, patent law, it arose out of the desire to regulate the guilds who were producing specialty goods. They served as an early form of quality regulation of products. And sometimes they were mostly just to say, the queen approves of this product, it is a good product, you should buy it. Copyright law functioned in a similar vein. It provided some space for publishers to invest in creating a work that they could then market and sell with some guarantee that it wouldn't be undercut by copies in the marketplace. So many changes have happened in the world that make intellectual property rights more or less useful rights. And more or less justifiable and more or less appropriate forms of entitlement. And I think that's a lot of what Professor Kalboli was talking about, was this idea that the intellectual property tool isn't the tool for all circumstances. And some societies have a strong prevalence of intellectual property rights and some don't. Most importantly to this talk, with the formal disappearance of these guilds or these specialist groups of people who were innovating, the growth of global supply chains, the massive growth of the market of commodities, the growth of consumerism and consumer capitalism, the formal rules of intellectual property law have grown to function in much larger international markets and to negotiate the interactions between many strangers, billions of strangers, in fact. It sometimes seems that intellectual property rights are everywhere. And I think that was another message from the previous talk, and that they govern everything. But in fact, evidently, that's not true. And that's what I wanted to elaborate a bit more, is what characterizes those spaces where intellectual property rules don't work, and what that in turn tells us about what intellectual property law is. So the main conclusion, so I'm going to tell you what my conclusion at the end is, and that speaks to this concept of legal traditions. So the idea that we're embedded in a legal tradition, be it the common law, the civil law, and indigenous legal tradition. The main conclusion is that the law of intellectual property expresses a series of values, beliefs, and ideologies, and it grows out of the soil of liberal individualism. And in spaces where the values of liberal individualism are not primary, the intellectual property right has no soil in which to grow. So it cannot flower, it cannot become a thing. And I'm going to move to my first case study. So my case studies generally take place in Canada because that's where I'm based. They're historical. I specifically choose the historical method because I think it reveals things in a broad context and allows some perspective for reflection and for understanding what is, what is really happening. So there have for literally centuries now, now that we're in the 21st century, been arguments over the merits of patenting anything medical. And in the early days of the medical profession, so in the late 1800s, there were many debates between folks who believed that basically anything medical should be patented, and those who strongly opposed this. And so the arguments for medical patenting covered all sorts of different grounds, and I think some of these will be familiar to you. So it protects an invention from getting into the wrong hands. It keeps researchers in public institutions if they can get a patent and then get some royalties. It makes sure that things get manufactured. I think this is a big concept at the moment with the COVID vaccines, and the question about whether they should be compulsorily licensed or open licensed. The question is it more motivating? Is it more helpful to have those covered by patents and protected, and then it protects a space for manufacture, or is that acting as a bottleneck to producing the supply? The arguments against medical patenting were that research becomes motivated towards profit and not curiosity, that it promotes a culture of secrecy because, of course, the patent has to not be anticipated. So there's an incentive to keep things secret in the development of medical products, that it leads to unfair rewards, which I think we see over and over again. So why does a particular invention get millions or billions of dollars, even in royalties, and some languish in obscurity? It's often based on the market that's available, that it chills research, that it leverages public funds to private gain, and that in a crisis you could use patents to restrict access to valuable products. And again, I think we're seeing some of those arguments playing out right in this very, very moment of the pandemic. The European Patent Convention answered this by excluding from patentability methods for treatment of the human or animal body by surgery or therapy, and diagnostic methods that are practiced on the human or animal body. So there's a lot more here, but the most important part is the practiced on the human or animal body. So anybody who reads the news now knows that pharmaceuticals are, of course, patentable. So this exception, this contemporary exception, doesn't cover things that are products that are sold on the market as such. It covers methods that are practiced on the human or animal bodies. So for example, that could be something like an allergy test that requires a skin prick, or a therapy a surgical technique, for example, that involves cutting in a particular way. So this exception is currently a part of the law of the European Patent Convention. It's worth understanding why, and the contemporary argument was that patents will not hamper a doctor's valuable life-saving work. And you can imagine that those arguments are powerful if somebody said, well, you can't practice this surgical technique because it's patented. I think something inside us would oppose that. But the question is, but it's weird because there are some things that are covered as medical exceptions and some things that aren't. And the pathway to that, to how that's developed, is very long, and I can't get into it all here. But I've been very interested in how doctors got this exception, how they managed to cut themselves out of the Patent Act, and how they managed to get out of patents, and even in this small way. And I found in my research that in fact that it had its roots in the early professionalization of medicine. So medicine wasn't always as organized as we see it now. Sometimes it's not as organized as we think it is even now. But in the mid-1800s, medicine was actually relatively unsafe and had limited efficacy. So the practice of medicine by medical practitioners. And part of this was because the markets were flooded by these patent medicines. And as you can see, they were a huge part of the patented goods in the patent system. 20% of the patent system by the late 1700s. Those who manufactured patent medicines, some of which contained very high concentrations of things like cocaine, heroin, and other drugs that we consider harmful at the moment, they were the largest quantity of things that were being patented, and they were considered accredited by the Crown. People during this period in the transition to an industrialized country in the UK were felt very sick. They called it was an age of self-conscious hypochondria, as one commentator has called it, this idea that people generally were not feeling good and they were asking someone to help them feel better, and they were taking these patent medicines to feel better. And so there was a great demand for physicians and for help. The drugs that were on the market were not good. They were generally not very helpful. And the medical practitioners were getting a very bad reputation as a result. People were saying doctors don't cure, sometimes they kill, in fact. And so the medical practitioners, observing this phenomenon, realized that they needed to, in fact, professionalize the practice of medicine in order to gain control over the product, which was medical practice and also the patent medicines. And they did this by distancing, so physicians organized, and this is again in the late 1800s in England, Canada, United States, Germany, parts of Western Europe. They did this by distancing themselves from the market. They did it by excluding regulation by other professions like law. They did this by getting the state to say, yes, you can self-regulate. They did this by saying this is what a medical practitioner does, so standardizing, controlling the medical commodity, and also by creating a certain esprit de corps. So by saying, like, when you're a physician, that means something, like you're part of this community, you turn to these values. The Hippocratic Oath is an example. So this idea that you're part of a community that believes in certain values that sits outside of the market. So I have an example here about encouraging collegiality between physicians. So the idea that physicians shouldn't fight amongst each other and they shouldn't try to undermine each other. And in fact, the British Medical Association passed a resolution saying that in 1903, saying that it's undesirable for a medical man to take out a patent on something that they've invented, and that these norms were enforced and elaborated by the British Medical Journal and other publications of the medical profession at the time, saying, in fact, answering questions by users saying, you know, can I patent this? And British Medical Journal writing back and saying, no medical practitioner should be selling anything that you should be recommending to a patient. So getting rid of these conflicts of interest that patents created, because patents are complicated. They're like, they can be very ethically compromising for those who are interested in treating patients with medical illnesses. And the medical profession at the time was very concerned to eliminate these kinds of conflicts. And so by the 1910s, the medical profession had in fact created something like a parallel to the patent system within its own practice. So they had secured a state-supported monopoly that evaluated their own inventions by peer review, so not through the patent scheme, but through each other. The incentive was reputation and the approval of other physicians. The disclosure and dissemination happened through the publications of the British Medical Journal and through the publications of the medical profession. The reward was a stable professional income, and the enforcement happened through the pages of things like the British Medical Journal and through meetings of physicians where they shunned and shamed each other. And so many of the functions of the patent system were taken over by the medical profession. I don't have time here today to sort of chart the progression of this informal norm through time and how eventually pharmaceuticals became easily patented, but medical methods still remain a bit of a taboo and outside of the patent system. But it has, I want you to retain from this the idea that when a community has its own norms about how invention is created, like how inventions are made, enforced, disseminated, then the patent system doesn't really have a strong soil in which to plant itself. It doesn't have much relevance. Briefly, I'll talk about two other areas I'm interested in. I looked also at soldiers and patents, particularly in the First and Second World War. In Canada in particular, because I have access to those archival records. What I found was that the military, the soldiers, the military professionals were not unlike the doctors. And I looked at the regulations that governed military life at the time. They were super interesting. And what I saw were in the regulations that govern soldiers' behavior. And so you can imagine soldiers on the battlefield are very, like, they want to innovate. They want better guns. They want better techniques of finding, of preventing, of not being attacked. They're constantly innovating, and they're innovating because their lives are on the line. Much like in medicine, they're innovating all the time. But what I found was that soldiers didn't tend to have many patents, and they weren't encouraged to patent. And one of the things I found was that the patent system was seen to interfere with military life. So I have it here. The threat was the disruption of the fabric of military life. So inventions were actually seen sometimes as dangerous to military life because they had unpredictable results. They might not have been tested. They could threaten to promote people outside of the official ranks of promotion within the military, so it undermined military authority of the leaders. Also, there was a concern as well in the military about conflicts of interest between soldiers who invented something and then might try and sell it back to the army and make money off it. And that was considered to be really deeply problematic. And the way they could make money off it would be by patenting it. And so the US and the Canadian military actually had restrictions against patents, saying you weren't allowed as a serving member to get patents at various moments, or that if you got a patent, you had to dedicate it back to the military or make it available to the public. So I was very interested in that. The result of that I've noticed is that when military people became involved in managing, and we see this in Canada now actually with the COVID vaccines, the military is actually managing the distribution of the vaccines. Often when there is a crisis, almost like a wartime crisis, the military gets involved in management. And I've listed here a series of mechanisms that military men who were in charge of various invention organizations in Canada adopted at the time to kind of get around the patent scheme. So things like patent pools and collective invention boards, defensive patenting, public interest patenting, which was patenting and then giving something back to the public interest, compulsory and non-exclusive licensing, all these mechanisms. Okay, so I've talked about patent. The third area that I wanted to talk about was copyright. And in particular, I've also done research into what I call independent music labels. So music labels that are Canadian, that are not international, like BMG or Sony, for example. They're music labels that are generally rooted in a particular city. They make up about a quarter of the Canadian market, so they're a big part of the Canadian music industry. And I'd worked with them for years, and what I'd been interested in was that I noticed that even though music is clearly copyrighted, and when you play a song on Spotify or wherever you listen to your music, it's covered by a whole host of intellectual property rights, from the rights to use it in film and the rights to the master and so on and so forth. What I found was that the independent music labels were not particularly interested in copyright and didn't really talk about it very much. And what I found was that within the Canadian music industry, there was a mismatch between what copyright was supposed to be doing and what it was actually doing. And so that in fact, copyright was the thing that music labels talked about when they were talking about moving or selling music to the United States, to their markets in the United States. But it actually had very little to do, and I think this goes to Professor Kalboli's talk a bit, is that they had very little to do with what they felt was motivating them to make music. And in fact, what was motivating them to make music was the Canadian grants regime. So Canada offers very generous grants to people to make music, essentially, and that was much more important to them than gaining copyright and then selling their music on markets. And what I found when I was interviewing these groups was that they essentially didn't believe in some of the precepts of the intellectual property marketplace, that they were essentially what I call illiberal. They didn't believe in many instances in the kind of liberal consensus around commodification and individual rights. and that that they were functioning in a completely different ecosystem. So I know that this has been very Canada focused. I need to speak to what I know about. I think these examples are deeply generalizable, because I think much of the world functions in a space where intellectual property actually isn't terribly relevant, except when you're talking about trade and also certain commodities on the domestic marketplace. I think in the examples that I've talked about, intellectual property was displaced or had no relevance because we were talking about professions that have very cohesive internal norms, that they often function in the public interest. So you can see in terms of medicine or fighting in the military, or even creating music, there's a sense that people are offering something, a gift. And I'm very influenced by the work of Indigenous scholars in my transsystemic program here at McGill, who have described this phenomenon of life worlds, or this notion that what ultimately counts as law is constrained by the constitutional order from which they derive life. So if your constitutional order, if the constitutional order of your organization or of the space you live in doesn't have space for this idea, then it doesn't subscribe to these values, and the intellectual property has no place to grow. And that even within a sort of Western, supposedly monolithic, I thought it was interesting the map that Professor Kaboli showed us about the rights of innovation, but also the sort of presence of intellectual property rights. Even within this kind of notion of a Western monolithic tradition of intellectual property rights, there are many stories of intellectual property and of intellectual property management, and also of intellectual property evasion. And I just want to leave that with you. So thank you very much.